All right. So a quick overview, introduction on Disability Rights California for those who might not know. We are a statewide nonprofit organization, and we provide free legal services to people with disabilities. Our agency was created back in 1978. It was called Protection and Advocacy Inc. back then. We changed our name to Disability Rights California in 2008 to better reflect on the issues and topic that we handle. We have offices throughout the state of California. I myself is in San Diego. Mary is in Ontario. We also have headquarters in Sacramento. We have office in LA, in the Bay Area, Fresno. We're spread out throughout California. And we handle a variety of topics from access or discrimination with education, which includes special education, which is our topic for today, housing, mental health, public benefits such as Medi-Cal or in-home supportive services, voting, regional center issues, Department of Rehab issues, just to name a few. Just a quick reminder for those who might have jumped in late, please do not put your questions or any personal info in the chat. This is being recorded. You can get a copy of the recording and the presentation materials after if you email your group coordinator, Mina, is in the chat. If you have any questions, please save them to the end. When we stop the recording, you can raise your hand with the reaction button or unmute to ask your questions. So without further ado, I am passing along to our presenter for today, Mary.
Thank you, Raymond. And I'm turning on my video just to introduce myself. My name is Mary Rios. I'm one of the senior advocates at Disability Rights California. And today, like Raymond said, we're going to present on special education and the IEP process. So I'm going to turn off my camera because I tend to have difficulties with my internet. So today we're going to cover special education, and like Raymond said, we'll save the questions for the end until the end of the presentation. So we'll get started. Next slide, Raymond. So today we're going to touch on child find mandate. We're going to do a brief overview of special education laws. We are going to cover special education eligibility, Section 504. There's a Section 504 plan, and what does that entail? The special education process. And we're also going to touch on compliance complaints and due process. Next slide. So child find mandate. What is child find mandate? Every school district has a responsibility of looking for children who may have disabilities and who may qualify for special education. Child find covers every child from birth through the age of 21. And every school district must reach out beyond their schools. They need to look into private schools. They need to look in different areas to see if they may identify children who may qualify for special education. Child find applies to all children who reside within California, including children who attend private schools and public schools, highly mobile children, migrant children, homeless children, and children who are awards of the state. So they have to go outside of their own school and see if there may be children who may qualify for special education services. Next slide. Special education laws. So what laws cover special education? There is the federal law, which is the Individuals with Disabilities Education Act, also known as IDEA. And there is the California state education laws. And this is, of course, state laws. IDEA entitlements, again, IDEA is Individuals with Disabilities Education Act. The individuals have, they're entitled to a free and appropriate public education, also known as FAPE, in the least restrictive environment, also known as LRE. There's a lot of acronyms, so I'm going to basically identify what they are. Assessments, they're entitled to assessments. They are entitled to an individualized education plan, also known as an IEP. People have right to file a complaint. They have a right to file for due process, which includes mediation or an informal administrative hearing. These are entitlements under special education, under IDEA. So when an individual qualifies for special education, they're entitled to a free and appropriate public education in the least restrictive environment. So what does that mean? It means that they are supposed to be provided an appropriate education at public expense that meets the standards of the state educational agency. They should include appropriate preschool, elementary, or secondary education, and they are provided in conformity with the individualized education program. And just to reiterate, free and appropriate public education at no cost to the parents, and they have to look at what is the least restrictive environment for the individual child. Next slide, Raymond. Again, the individual has a right to receive services in the least restrictive environment with supports to the maximum extent appropriate with opportunities for children with disabilities to interact and be educated with children who do not have disabilities. Typically, when a child is assessed, the assessments identify where they're at academically, what their limitations are, what their strengths are, what their weaknesses are. And the first thing that should be done is they need to look at the general education setting with their typical peers. And in some cases, a child may need some additional supports and services to remain in the general ed setting. In some cases, they may be placed in a special day class if a general education is not an appropriate placement. So schools must provide supports to ensure success in the regular education classroom. Next slide. So what is special education? Keep in mind that special education is not a place. Special education are services that a student receives if they qualify for special education. It's a pool of services available to qualifying students with disabilities that ensure the receipt of a free and appropriate public education. And who is eligible for special education under federal and state law? So a child is eligible if they have an intellectual disability, hearing impaired, including deafness, speech or language impairment, a visual impairment, including blindness, if they have a serious emotional disturbance referred to in this part as emotional disturbance, orthopedic impairment, autism, traumatic brain injury, or other health impairment, specific learning disability, deaf, blindness, or multiple disabilities, and who by reason thereof need special education and related services. So the other thing is that just because they have a disability, it doesn't mean that they're going to qualify for special education. Can we go to the next slide, Raymond? So all students age 3 to 22 must have an assessment, and the assessment must demonstrate that the student's impairment adversely impacts his or her educational performance and therefore requires special education. Again, just because they have a disability doesn't mean that they're going to qualify for special education. Their disability must demonstrate that the students that it adversely impacts their education. Here we included a link, which is Chapter 2 of our Special Education Rights and Responsibilities Manual, and it talks about the assessment process and the different types of assessments that are available. And later, I'm going to go ahead and share our website, and we'll do that towards the end of the presentation. So what other laws cover special education or individuals with disabilities? There are applicable federal laws. These are anti-discrimination laws. There's Section 504 of the Rehabilitation Act of 1973 and Title II of the Americans with Disabilities Act. These are anti-discrimination laws that are federal laws that also cover individuals with disabilities. Next slide. So what is a 504 plan? So students who do not qualify for special education may have a disability that where they have difficulty accessing their education for some reason, who may need an accommodation or modification to gain access to and benefit from the school's program. So many students who do not qualify for special education may need an accommodation. For example, there may be a student who uses a wheelchair who needs an accessible desk where he or she can easily roll under the desk. They may need an accommodation where they need more time to either submit homework or take a test. So these are accommodations and or modifications that the school can create in a 504 plan. So the 504 plan needs to be developed. They need to include any and all modifications and reasonable accommodations that the student may need to access the school's programs. So Section 504 eligibility is not based on a categorical analysis of disabilities. Rather, Section 504 protections are available to students who can be regarded as disabled in a functional sense. So these students must have either a physical or mental disability, which substantially limits a major life activity such as learning, sleep disorder, depression, substantial emotional trauma, or they may have a record of such impairment, or they may be regarded as having an impairment. Next slide. Thank you, Raymond. Again, 504 plan students eligible under Section 504 receive a 504 plan, and again, it must include any accommodations and or modifications that the school is going to provide the student to make the programs accessible for the students. In contrast to IEPs under IDEA, students and parents may receive fewer guarantees and procedural protections under 504. Nonetheless, it does provide foundation for disability-based discrimination claims. So again, a 504 plan is covered under Section 504 of the Rehabilitation Act, which is the federal law. Next slide, thank you. So here we included some examples of reasonable accommodations, and these are just some examples. Parents may be creative if their child needs an accommodation or modification that may work for them. But these are some examples, like accessible desks for student in a wheelchair, special seating in the classroom. Sometimes the student may need to sit up in front of the class because they have difficulty either seeing, or it's where it's easier for them to either listen to the teacher or look at the materials that they're presenting. They can also record a lesson. They can modify the homework. And what I mean by modify the homework, let's say, for example, there's a student who needs modification in their homework. They can ask for less homework than what they would give a child in general education. Let's say, for example, they're having difficulty with their homework. They can ask for modifications in the assignments. They can also ask for quiet space for testing. extra time to take a test or to take a quiz. And there's many more accommodations. There's different types of accommodations and modifications that can be provided. Some people ask us, what other modifications or accommodations are available? We usually suggest that you Google reasonable accommodations in the school. There are many sites that have a lot of information available. So we covered the first section. Now we're going to cover the special education process. So we'll go to the next slide, Raymond. So here is the special education process. So what happens if a parent suspects that their child has a disability, or there's a referral for a child who somebody may suspect that the child has a disability? A referral is made. If the parent suspects that their child has a disability, they can write a letter to the school district and to the school, primarily to the school, and CC the school district. I always recommend CC the school district. So you write a letter basically saying, my child attends X, Y, and Z school. My child is having difficulty. I suspect they may have a disability. I am requesting that you do a comprehensive evaluation to determine whether they are eligible for special education. Always remember that when you submit a letter to the school, keep a copy. Always keep a copy for your records. Why do I say that? It's really important to, and not only to the school district, with any organization that you're dealing with. It could be Social Security, it could be IHSS, with a regional center. Any communication, keep notes, keep copies of who you spoke to, write down who you spoke to. If there's correspondence in writing, make sure that you always make copies. It's always important to keep copies. So once a request is submitted to the school district has 15 days to respond to you with an assessment plan. The assessment plan will indicate the types of assessments that are going to be done. If you agree to the assessments, you sign the assessment plan and you return it. And again, you want to keep a copy of the assessment plan. Once the assessment plan is submitted, the school district then has 60 days to complete the assessments and hold an IEP meeting. Once that happens, they make the determination. They determine whether the student is eligible or not eligible. If the student is found eligible, an IEP meeting takes place, an individual educational plan is developed. They talk about services that are needed, placement, and we'll cover that in further slides. The IEP then takes place every year. And just keep in mind that you don't have to wait for the yearly IEP. If your child is having difficulty in school, you can always, the parent has a right to request an IEP meeting at any time. Once the parent requests an IEP meeting, the school district has to hold an IEP meeting within 30 days. So that's really important to know as well. So the annual IEP takes place. And then there's a triennial IEP meeting that takes place. What's involved in the triennial? The school district has to evaluate the student in all areas. Why do they do that? Excuse me. They do that to determine where the student is academically. They also do the triennial evaluations to determine whether the student continues to need the services that they're receiving, or if they don't need the services, or if they need additional services. They may need, say for example, they're receiving services and then they do the triennial and they determine that now the child needs speech therapy. So it could be an additional service that the student may need. Thank you, Raymond. So this is an example of an assessment plan. And it has all the information on the assessment plan. Of course, keep in mind that every school district has their own IEP, their own document, their own assessment plans, but they basically contain the same information. It has whether it's an initial assessment, an annual assessment, triennial, if it's a transition, an interim, or other. And it has all the information, the parent, the name of the parents, the district, the name of the school, the grade, birth date, primary language, and the reason for the referral is also important. So this is a bottom portion of the assessment, of the sample assessment. It indicates the type of assessments that are going to be completed: an academic achievement, a health assessment, intellectual development assessment, language and speech, motor development. So these are all the types of assessments that are done with the initial comprehensive evaluation. In some cases, there may need to be a different type of assessment that the student may need. Here where it says other, and these boxes are usually checked off if they're going to evaluate in those areas. But in the section where it says other, if you feel that the child needs a specific assessment, you can include that on there as well. And then of course it has the boxes on whether you consent to the assessment, if you do not consent, and then parent signs it, they date it, and then down at the bottom, it's really important in the comments section that you include whenever the school district is going to complete any assessment. It's always important to include, please provide copies of the assessment reports at least 5 days before the IEP meeting. Why do you want to put that? The reason you want to request copies of those reports is because you want to have an opportunity to review the assessment. You want to see what the outcome of assessments, what happened with the assessment, where your child is, what the strengths are, what the weaknesses are. And I'll tell you, because the assessments are what drive the services and the supports that the student is going to receive. You know, and we're not well, I'm not a doctor, and I know some of the assessments are very difficult to understand, but you know your child and you want to read through the assessment. If for some reason you disagree with the assessment, you also want to make it known. And that's why you want to request copies of the reports before the IEP meeting. Next slide. So what type of assessments help identify the student, what the student needs? These are some examples of assessments, such as occupational therapy, physical therapy, speech therapy, the functional behavior assessment, that is if a child is having difficulty with behaviors, the assistive technology evaluation. I think that's one of a really important assessment. And I say this because many times when the students transition from early start to the school district, many students that we've encountered may have either speech difficulties or are nonverbal. When students are nonverbal, you want to ask for an assistive technology evaluation to see if there is some type of communication device that the student may need. They also do social, emotional, and behavioral needs. They also can do an educationally related mental health services evaluation, a one-to-one aid support, and many more other different types of assessments that the school district can do. Excuse me. So when you review the assessments that the school district does, let's say, for example, you review the assessment and you disagree with the assessment that was done. You see something on the report that is not identifying your child, and you disagree with it. Parents have a right to request what's called an independent evaluation. If you whenever you disagree with an assessment that the school district has completed, you have the right to request it's also known as an IEE, an independent education evaluation. And the school district has two options. They can either approve the independent evaluation, or the school district has to file for due process and prove that the assessment that they completed was an appropriate assessment. And here we included a sample letter on how to request an independent evaluation. So when there is an IEP meeting, the school district has to provide the parents written notice that they want to have an IEP meeting, or when the yearly IEP meeting is going to take place. And it should be scheduled on a mutually agreed date and time. If for some reason you cannot attend the date that the school is setting, you contact the school district and let them know that you cannot attend and that you want to request a different date and time. And again, it's really important to put it in writing. Parents have the right to request an interpreter if English is not their primary language. And if that is the case, one suggestion is that you take somebody to support you at the IEP meeting. And if the parent is not, if English is not their primary language, you want to take somebody that understands both, that can speak both English and their language. And the reason I say this is because when there is an interpreter, you want to make sure that the interpreter is interpreting the things that are taking place or that are being said correctly. There have been situations where there have been interpreters that are not interpreting what is being said and are also giving their own input. That should not be taking place. Parents also have the right to record the IEP meeting as long as they give the school district 24-hour written notice. So if you intend on recording the IEP meeting, make sure that you write a letter or an email letting the school district know that you're going to record the IEP meeting. Here we included Chapter 4 of our Special Education Rights and Responsibilities Manual, and it's a really good chapter. It talks about the IEP process and everything you need to know about the IEP process. So the IEP meeting, again, an IEP is an individualized education plan. It should be created based on what the student needs are. And remember, it's a legal contract between the school and the student or the parents. The IEP, you want to make sure that all the services and accommodations, modifications are written into the IEP. If it's not written into the IEP, it doesn't exist. So if they tell you verbally, we're going to provide this service, you want to make sure that it's written into the IEP. The IEP must be held annually and after an assessment is completed, or when the parents request an IEP meeting or an assessment. If requested by the parent, the school must convene an IEP meeting within 30 days of the written request. The purpose of the IEP meeting is to meet with the parents to discuss all relevant assessments and information to design an offer of a free and appropriate public education for the school year. If appropriate, you may want to take the student as well if they want to give their input. So how to prepare for an IEP meeting? Again, if it's appropriate, take your child with you. You want to make a list of what you and your child would like to happen for the school year. You may want to write down notes about any goals and objectives, any needs, and any concerns that you have. It's really important to check on the previous IEP if you had one the year before. You want to make sure that that the goals and objectives are being met. If they're not, you definitely want to write questions down in terms of why they're not being met. Are the goals and objectives, are the goals too difficult? Should the goals be changed? Are they realistic? You want to make sure that they include appropriate goals for your student, for your child. Check in with friends and family again to see if someone can come to support you at the IEP meeting. You want to provide the school with 24-hour notice if you plan to record the meeting. And remember, you can only audio record. You can't record the participants' faces unless you get authorization from them. Provide written requests for any accommodations that are needed, or if an interpreter is needed. Again, you want to review last year's IEP if you have one. Review any assessments made. If you disagree with any of those assessments, you have the right to request an independent evaluation. Review any materials you've received throughout the year. Or if you had an IEP meeting last year and they provided you with any homework assignments and reports, you definitely want to review those. You want to review any disciplinary records, any report cards and progress reports, and student work. Again, you want to review, if you have last year's information, you definitely want to review that. And again, you want to review the goals and objectives to make sure they're appropriate. You want to make sure that you question if the student's not meeting the goal. Why aren't they meeting their goal? How are they reporting to the parents where they're at in terms of benchmarks? You definitely want to have that discussion with the IEP team. Next slide. So who are the IEP team members? The parents are definitely members of the IEP team. There should be a special education teacher, a general education teacher, a school district representative who's authorized to make decisions on any supports and services that the student needs. Any service providers such as speech therapists, occupational therapists, physical therapists, and you definitely want them there to provide you with reports on how the student is doing. Any person who conducted an assessment, if there was a speech therapist that did an assessment, or if if they did an AT assessment, you definitely want to have that person there to provide information on the report and the evaluation that was done. You want to take a parent or a friend, or if you have an advocate, make sure that they go with you. They're also part of the IEP team. What must be included in an IEP? Eligibility. So you want to include, they want to include what the eligibility category is, whether it's specific learning disability, autism, other health impaired. Present levels of performance, again, those must be included in the IEP. Goals and objectives should also be included in the IEP, and they should have timelines. Any related services such as speech therapy, occupational therapy, and you want to make sure that when the related services are written into the IEP, that they're very specific in terms of when the student is going to receive the service. Are they going to receive the service once a week, twice a week, 30 minutes each time, 15 minutes each time? You want to make sure that it's very specific in the IEP. Any accommodations and or modifications should be written into the IEP. Any behavioral plans individualized transition plan if it's appropriate. So when the student turns 16, the school district must do what's called a transitional plan. They should evaluate the student again to see where they're at academically. No later than 16 than the age of 16. They should include in the transition plan what the student wants to do out in the community once they finish school. Do they want to pursue higher education? Do they want to work? Do they have a vocational goal? They need to develop a transition plan to identify what the student is going to do once they leave school. The IEP should include the classroom placement, whether it's if the student is placed in the general ed placement. It should also include if the child is placed in special day class and how much time they spend in the general ed class and how much time they spend in a special day class, because many times they will split the time. So some students may be in a special day class. However, for recess or for lunch, they participate with their general ed peers, or they may have a class, a science class in the general ed. So it should identify what the percentage is that they spend in general ed and what the percentage is that they spend in special day class. Any team notes, computerized system or handwritten. If the district will, and the parents have the right to include their notes as well. And if the school district does not let you include notes, you have the right to file a compliance complaint. Next slide. Parents' rights at the IEP meeting. Parents have the right to meaningful participation at the IEP, asking any and all questions. You should, create your agenda and highlight any bullet points that you want to talk about. Take time to think about the IEP before you go to the IEP meeting. Make a list of all the questions that you want to ask. Parents have the right to an interpreter at the IEP meeting free of charge. It must be requested in advance. Again, parents may record the IEP if they give 24-hour written notice. Parental consent. The IEP has to be signed before the school district can provide services. Parents have three choices. They either consent, they disagree totally with the IEP, or you can consent to parts of the IEP. There may be, let's say you agree to placement, but you disagree with the amount of services that they're going to provide for speech. You can partially agree with the IEP. Doesn't mean you have to agree to everything. I would recommend that you take some time to review the IEP before you sign it. You want to make sure that you understand what's written in there, if the goals are appropriately written. You want to make sure all the services that you discussed are written into the IEP, because remember, again, the IEP is your legal contract. If a service is not written in the IEP and it was discussed, if it's not written in the IEP, it doesn't exist. So you want to make sure you have time to review the entire IEP. You can ask for a copy, take it home, let them know that you're going to review it, and that you'll get back to them with the signed IEP, whether if you agree to it in total or partially. But take it home, review it. If try to find somebody that you can review it with. Parents must receive a full final copy of the IEP, and again, do not leave without it. If English is not your preferred language, you may request a copy of the IEP in your primary language. I will say that there is no timeline in terms of when the school should provide the IEP in your primary language. What it does say is that it has to be done within a reasonable amount of time. I happen to think that's, a month to 6 weeks is a reasonable amount of time. And if it's not provided to you and you don't, if English is not your primary language, again, you want to review it with somebody that can read the English and tell you what is written, at least until you get the translated copy in your primary language. Next slide. So, right to file a compliance complaint. So can you, yeah, thank you, Raymond. A compliance complaint is with the California Department of Education. It's investigated directly by the California Department of Education. File when special education laws or procedures have not been followed. Some examples are if you request an IEP meeting within 30 days and the school district is not providing you with a meeting, or let's say that they're not meeting the timelines in terms of assessing the student within 60 days, or if they're not having an IEP meeting, that is a compliance complaint. They're not complying with the procedures. CDE must receive your complaint no later than 1 year after you claim the violation of special education law occurred. So, and then CDE, the California Department of Ed, has 60 days to investigate. So you want to make sure that if the school district is not complying with the procedures, you file a compliance complaint. And then there's the civil rights complaint. Civil rights complaint is filed with the U.S. Department of Education, Office of Civil Rights. And you can file regarding allegations of discrimination based on disability. And that complaint must be filed within 180 days, which is equal to 6 months of the allegation of discrimination. There is no investigation timeline. So if you do file a complaint, there's no telling how long that complaint could take to be investigated. We included our link here to Chapter 6, which talks about your due process rights, which includes the compliance complaint, due process, civil rights complaint. It has a lot of information, and it has information in terms of addresses where you need to file your complaint. It's a really good chapter. Our Special Education Rights and Responsibilities Manual has, I believe, 16 chapters. And it's everything you need to know about special education, and it comes in a question and answer format, and it's very easy to understand. Next slide. So due process pre-hearing resolution, if you file a due process request, the district must offer you a meeting. It's a pre-hearing resolution. But if the district files for due process, the district does not have to offer the pre-hearing resolution. Attorneys for the district may not attend unless the parents are represented by an attorney. Must be able to discuss the basis for your complaint, and the district is given an opportunity to resolve it. All discussions are not confidential and can be disclosed in a subsequent hearing or court case. So remember, whenever you have these pre-hearing resolutions, they're not confidential. Good practice is for both sides to agree to confidentiality at the meeting. So that's something to take into consideration. If there is an agreement, if they offer you an agreement or you come to an agreement, make sure that it's in writing. It must be in writing and signed by both parties. The agreement is legally binding on you, and it can be enforced in court. Either party, you or the district, have 3 days after signing the agreement to revoke your signature on that agreement. The resolution session must occur within 15 days of the district receiving the parent's request for due process. And it must be finished within 30 days of the district receiving the parent's request. So this is in terms of the pre-hearing resolution. Next slide. Mediation and due process. Mediation is an effort and attempt to compromise and come to some resolution of the disagreement. Both sides have to agree to mediate. It's facilitated by an independent mediator. Mediation does not change the 45-day timeline. Although parents are sometimes asked to extend the 45-day timeline, sometimes they will do that. You can still go forward with due process if mediation is not successful or only a partial agreement is reached. So let's say you come to an agreement in mediation partially, but the other part is not agreed upon, you can still continue with your due process claim. What is said in mediation is confidential, that cannot be disclosed. And then due process. A due process is an administrative fair hearing, and your due process must be filed within 2 years from the date of the alleged action. So what is due process? You can file a due process if, for example, you disagree with a service, you disagree with placement, if you disagree with any service, say for example, you're requesting speech and the district is in disagreement and they say that based on their assessment, we don't feel that the child or the student needs speech assessment. However, you think that your child needs speech and you have an assessment, and what happens is it becomes a challenge among a battle between both evaluators, and therefore you can file for due process hearing if you disagree with a service that is not being provided or a service that is being provided and you're asking for more additional time. So again, it must be filed within 2 years from the date of the alleged action, within 45 days for a hearing, for a fair hearing. It takes place within 45 days once you file for due process. It's heard by an impartial hearing officer, and it's not a formal trial. And again, we showed you the link for more information about due process here, about the due process hearing in our chapter 6. Next slide, Raymond. So I'm going to take a second to share our website before we go into the questions. Can you see the website, Raymond? Can you all see the website?
Yes.
Okay, great.
Yes, we
Thank
can.
you. Okay, so this is DRC's website, and we have a lot of good information on here. But for any publications, that is listed under resources, and it's by topic. We also have in the majority of our publications, you can select the language, but here are the publications and the topic areas. So since we are covering special education, I'm going to click on special education, and we have lots of them. We have toolkits on special. This is our special education basic toolkit. We have behavior and discipline toolkit. If there's disagreements with the school district, there's a toolkit on that. Also, we also have a toolkit on extended school year, and I'll just open the basic one just so you can see what's included in here. So we have our special education, our 17 tips, know your rights wallet. This is really good information for you to carry with you. We have special education timelines and terms. I wanted to show you this one really quick because it's really important for parents to also know the various terms, the acronyms that are used. And this is listed on here. You can also print this information and have it with you. That way you become familiar with all the acronyms and the terms that are related to special education. So I'm going to go back here And there's some additional information. There's understanding psychoeducational evaluations, how to obtain an independent evaluation at public expense. We have a publication on ERMS, which is educationally related mental health services. But I also want to go to our special education rights and responsibilities manual. Again, this has 16 chapters. Very, very good information. I'll click on chapter 2 that talks about the assessment process. And it comes in a question and answer format. So for example, how can I get the school district to evaluate or assess my child? You click on it and it'll give you the answer. This is, and it not only gives you the answer, but it has the federal code, it has the educational codes on here. So you can include those whenever you feel you have to write a letter. It's really good information. So I want to go back, and I also want to share with you the appendix. We have an appendix that has sample letters. There's a sample letter on how to write a request for an assessment, how to request records on independent educational evaluation. We also have a sample on a compliance complaint. What should be included in a compliance complaint, where to mail the compliance complaint, sample request for mediation and or hearing complaint. So all this information is really good. We also have attachment P. So when the student is about to turn 18, the school districts usually tell parents that their child is going to turn 18 and they can no longer attend the IEP meeting. So this document here, and I'll open it. It's a simple document and it has the California Education Code. And if your child understands and comprehends what's in this document, they can easily write a letter or use this sample and just, it basically says that I, the student's name, give basically saying having reached the age of 18, having never been determined to be incompetent for any purpose by a court, basically giving authorization to the parent or whoever they want to designate to make any and all decisions regarding their free and appropriate public education or the IEP meeting. So this is really helpful as well. But again, all our publications, and they come in several languages, but I wanted to share that information with you. We also have, for those of you who have children who are clients of the regional center, we also have rights under the Lanterman Act, and that is, sorry. Oh my goodness. That is here, rights under the Lanterman Act. And again, this has, I believe it's 11 chapters. 11 chapters. And again, it talks about eligibility, it talks about the IEP process, advocating for yourself. And it also, I believe, has, I'm not sure if it has a sample. Yes, it does. So it has additional information on here. So I wanted to share that with you as well. So I will stop talking now and I will wait for any questions.
So before we go into Q&A, thank you, Mary. If you have any questions that that you'd like to speak to one of our advocates privately, you're more than welcome to give our intake line a call. It is in the chat right now, 800-776-5746. And I believe that you can also reach out to Mary, our presenter today. I will put her contact information in the chat as well. So now I'm going to pause the recording. I'm going to stop the recording